All right, Donald Trump thought he held all the cards. 23 hours ago, he was standing at a podium, tie loose, fist pumping, telling a packed arena that the courts had nothing on him. Right now, a decision just landed so fast, so clean, so completely unexpected that his own legal team couldn't get ahead of it before the cameras caught their faces. The ruling, the reaction, the moment that legal experts are already calling a turning point nobody saw coming. What happened in between is the story everyone is scrambling to spin before you understand it yourself. Because this isn't about politics. This isn't about which side you're on or which news channel you trust. This is about a court that looked at months of procedural maneuvering, looked at a strategy built entirely on delay and exhaustion, and said two words that silenced an entire legal team. Enough. Finally. That's what this ruling means in plain English. And when you see what they ordered next, you'll understand why Trump's reaction wasn't just angry. It was something his allies had never quite seen before. So what pushed the court over the edge? One pattern, one strategy, one calculated bet that the system could be stalled indefinitely. For months, his lawyers moved filings like chess pieces, each one designed not to win but to buy time, not occasionally, systematically. But here's the thing. This wasn't the court being aggressive. This was the court finally running out of patience with a game everyone in that building could see being played. And I'm going to show you exactly how it all collapsed in a single afternoon. See, most people think this story starts with the ruling. It doesn't. It starts with a strategy that worked everywhere else, in business disputes that stretched across decades, in litigation that buried opponents under legal costs until they quit. The delay playbook, his team had run it before. They had run it successfully, and they walked into this case expecting to run it again. That's not a rounding error in judgment. That's not aggressive legal maneuvering. That's a miscalculation so fundamental it exposed everything underneath it. And this was just one ruling, one door closing in a hallway full of doors that are now one by one being shut. So let's go back to the beginning, not the convenient beginning that fits a particular narrative. The real beginning. For months, Trump's legal strategy in this case followed a pattern that anyone paying attention would recognize immediately. Delay, challenge, appeal, file motions that force the court to slow down, buy time, make the process so expensive and exhausting that the other side loses the will to fight. It worked before. It worked in business disputes that stretched across decades. It worked in litigation that most people gave up on before it ever reached a meaningful conclusion. His lawyers are good at this. Genuinely good. They know the procedural landscape of American courts the way a chess player knows the board. Every move designed not just for the immediate effect, but for the position it creates 3 moves later. And for a while, it looked like the same playbook was working again. Filings were being contested. Timelines were being negotiated. Legal arguments that seemed settled kept getting reopened, relitigated, stretched out like taffy, until nobody could quite remember where the original argument had started. People who follow these cases professionally started to notice something they've seen before. The stall. The deliberate, calculated, methodical stall. And then the court did something nobody expected. It stopped playing along. That's the only way to describe what happened. The judges looked at the docket, looked at the timeline, looked at the pattern of delays, and decided they were done waiting. The ruling came down with a speed that legal veterans are still struggling to process. One attorney who's practiced in federal courts for over 30 years told a colleague something that got back to me. He said he'd never seen a court move like that on a case this complicated. Never. In 30 years. The decision itself wasn't what stunned people first. It was the timing, the sheer velocity of it. When courts move that fast, it means they're sending a message. And the message was received loud and clear by everyone in that building, except apparently the one person it was most directed at. Trump wasn't in the courtroom when it happened. He was, as has become his signature move, somewhere else entirely. Somewhere with cameras and crowds and the familiar roar of supporters who genuinely believe that every legal action against him is proof of a conspiracy so vast it spans courtrooms, prosecutors' offices, and judges appointed by presidents of both parties. He was doing what he does when the legal walls close in. He was performing, and performing well enough that his base was energized, donations were flowing, and the message of persecution was landing exactly where it was aimed. Then his phone started ringing. The moment Trump's legal team reached him, something shifted. People who've watched him handle legal crises before describe a specific pattern. There's initial disbelief. Then there's the calculation, the rapid internal assessment of how bad this actually is and what can be done about it. Then there's the public response, which is almost always the opposite of what's happening internally. When the public response is loud, angry, and personal, it usually means the internal assessment is grim. This response was the loudest in recent memory. He went to Truth Social within hours, not days, not after consultation with his communications team, hours. And what he wrote was the kind of thing that makes lawyers cover their eyes, not because it was wrong necessarily, but because it was fuel. It was gasoline poured on a fire that his own attorneys had been desperately trying to contain within the boundaries of appellate procedure and legal decorum. He called the decision rigged. He called the judge compromised. He called the entire proceeding a continuation of the witch hunt that by his count has been running for almost a decade now. He used words that his lawyers almost certainly advised him not to use. He named names. He made accusations that will be quoted in the next filing against him, probably by next week, possibly sooner. And the thing is, if you've been watching this man for any length of time, none of that surprises you. What surprises you is the desperation underneath it. Because if you read past the performance, past the familiar rhetorical architecture of grievance and counterattack, you can hear something that wasn't always there. Something that sounds uncomfortably close to fear. Not the strategic fear that smart people feel when they identify a real threat and move to neutralize it. Something older than that. Something more personal. Here's the context that most coverage is glossing over because it complicates the easy story. This ruling didn't arrive in isolation. It's part of a cascade, a legal cascade that started building momentum months ago and has been accelerating in ways that even Trump's most pessimistic advisors didn't fully anticipate. The appeals court didn't just rule on one issue. They ruled on multiple aspects of the case simultaneously, which is itself unusual enough to make legal observers take notice. When courts bundle decisions like that, it typically means they want to close off the procedural escape routes all at once. They're not just deciding the immediate question, they're reshaping the entire board. And the way they reshaped it left Trump's team with fewer options than they started with. Not no options. These lawyers are too good to ever run completely out of options, but fewer, significantly fewer. And the options that remain are harder, more expensive, and carry higher risks of failure than anything they've attempted so far. The financial implications alone are staggering. Each procedural loss in the appeals process tightens the window for delaying enforcement of the original judgment. The clock that was already running is now running faster. And the numbers attached to that clock aren't small. They were never small, but with interest accumulating, with additional costs being added by each round of litigation, the figure is now something that even genuinely wealthy people would find difficult to absorb without serious structural consequences. Former financial advisors who've worked with major real estate empires describe what happens to a portfolio when liquidity gets squeezed this hard. Properties that were never for sale suddenly have to be considered for sale. Deals that were being structured with long timelines have to be reconsidered. Lenders who were comfortable get nervous. And when lenders get nervous in real estate, everything becomes more complicated, more expensive, and more precarious, regardless of what the underlying assets are actually worth. Trump's people know this. His financial team knows this. His legal team knows this. And yet the public posture remains defiant, remains certain, remains utterly confident that this will all be reversed, overturned, vindicated, just like everything else has eventually been vindicated in his telling of his own story. But the timeline for that vindication is getting harder to see. Let's talk about the legal team itself for a moment. Because this is where the story gets genuinely complicated in ways that casual observers are missing. Trump has assembled, at various points in this legal marathon, some of the most capable appellate attorneys in the country. People who went to the right schools, clerked for the right judges, built careers arguing in front of courts that don't forgive sloppy work. These are not people who stumbled into representing him. These are people who made a calculated professional decision that this case was winnable, that their skills were sufficient to the challenge, and that the reputational risk was worth taking. Some of them have already left. That's not a secret. High-profile departures from legal teams get noticed and reported. And when you lose lawyers of a certain caliber, the reasons matter. Sometimes it's fees. Sometimes it's strategic disagreement. Sometimes it's something harder to articulate, a sense that the case has shifted into territory where winning requires approaches they're not willing to take. The lawyers who remain are still fighting, still filing, still crafting arguments that in isolation have genuine legal merit. But the pattern of rulings suggests that the courts hearing those arguments are not being persuaded at the rate Trump's team needs them to be persuaded. And in appellate litigation, when you stop winning on the margins, when the small procedural victories that buy time stop coming reliably, the momentum shifts in ways that are very difficult to reverse. What the Swift ruling told the legal team, what it told everyone watching, is that the court has run out of patience with the strategy of exhaustion. And courts that have run out of patience are much harder to work with than courts that are still in the discovery phase of their frustration. The legal team reacted to the ruling with public confidence. Press statements, carefully worded, full of the appropriate language about pursuing every available avenue and being confident in the strength of the appellate arguments and trusting in the American legal system. Standard language, practiced language, but behind that language, behind those press statements, sources describe a team that spent the hours immediately following the ruling in something approaching controlled panic. Not paralysis. These professionals don't panic into paralysis, but the rapid, almost frantic reassessment of strategy that happens when a major assumption about how the case is developing turns out to be wrong. The assumption that was wrong was time. They thought they had more of it. Now here's the part of this story that cuts deepest. The part that goes beyond legal strategy and financial exposure and gets into something more fundamental about what's actually at stake. Trump has built an entire political identity around the idea that the system cannot touch him, that he is the singular force capable of withstanding the full weight of institutional opposition and emerging not just intact but strengthened. Every indictment became a fundraising moment. Every verdict became a rallying cry. Every legal setback became proof of the conspiracy that his supporters believe is the defining fact of American political life right now. That narrative requires something crucial. It requires that the outcomes never actually be permanent. It requires that there always be another appeal, another procedural move, another angle that keeps the final resolution perpetually out of reach. Because the moment outcomes become permanent, the moment the consequences land and stay landed, the narrative breaks. And this ruling moved things closer to permanent than anything that's come before it. That's not a small thing. That's not just a legal development. That's a political earthquake that's still being registered, still being measured, still being understood by the people whose job it is to understand these things. Trump's political operation is extraordinarily good at turning adversity into energy. They've done it more times than anyone thought possible. But turning this particular development into energy requires arguments that are getting harder to make convincingly. The argument that everything is rigged works when you're winning in some courtrooms, even as you lose in others. It works when you can point to procedural victories that suggest the tide might turn. It works when the timeline remains open-ended enough that resolution feels perpetually postponed. When courts start moving quickly, when they start issuing comprehensive rulings that close multiple doors simultaneously, the argument gets harder to sustain. Not impossible. Nothing is impossible in American political rhetoric right now, but harder, measurably harder. And Trump's reaction, the speed of it, the intensity of it, the unmistakable rawness that underlies the familiar language of grievance and counterattack, suggests that somewhere underneath the performance, he understands this. The reaction from his allies followed within hours, which is itself telling. In a normal political operation, allies coordinate before they speak publicly about major legal developments. They get on calls, they align messaging, they make sure everyone is saying the same thing in ways that reinforce each other. What happened here was less coordinated than usual. Different allies said different things. Some went hard on the persecution narrative. Some focused on constitutional arguments about the scope of judicial authority. Some were notably quieter than they typically are after Trump legal developments. And quiet in politics is never actually quiet. Quiet is a message. Quiet is people calculating their own exposure. Because here's what sophisticated political observers know about this moment, that casual followers might not. The people who've tied themselves most closely to Trump's legal victimhood narrative have made a bet. The bet is that the narrative holds, that the outcomes never become so final, so concrete, so impossible to spin, that the people who backed the narrative get damaged by association with its failure. That bet is getting more complicated to hold. Nobody is abandoning ship. Let's be absolutely clear about that. The political costs of abandoning ship right now, with a presidential election in recent memory and the base as activated as it's ever been, those costs are prohibitive for anyone who wants a future in Republican politics. You don't leave Trump while the fight is this hot and expect to survive politically. But staying becomes more expensive with each ruling like this one, and the expense compounds. Letitia James has said nothing publicly since the ruling. That silence is louder than anything she could have said. Prosecutors who are winning don't need to talk. They let the ruling speak. They save their words for the moments when they're announcing next steps. And when Letitia James announces next steps, they tend to be significant. Her office has been preparing for multiple scenarios simultaneously. That's how professional prosecutors operate at this level. You don't build a case for years. Win a historic judgment, watch the appeals process unfold, and then improvise your response to the outcomes. You have teams ready for each scenario, and you execute the plan that fits the outcome you get. The outcome they got with this ruling fits one of their better scenarios, not their best case. Courts rarely give prosecutors their absolute best case on appeal, but a strong scenario, one that keeps enforcement momentum moving forward while the remaining appellate arguments play out. Sources close to the Attorney General's office describe a team that is methodical to the point of being almost mechanical about all of this. They don't celebrate, they don't gloat, they move to the next step in the plan. And the next step involves timelines and deadlines that are now closer than they were 24 hours ago. When those deadlines arrive, and they will arrive, the question of what Trump does or doesn't do with liquid assets becomes very practical very quickly. Not theoretical, not a negotiating position. Practical. The kind of practical that involves court officers and property records and financial accounts. That is the reality that Trump's reaction is ultimately responding to. Not the politics of it, not the narrative. The simple, mechanical, inexorable reality that American courts have enforcement mechanisms that eventually work regardless of how loud the person being enforced against is willing to be. Here's what nobody wants to say on camera, but everyone is saying in private. The legal strategy has a ceiling. Every legal strategy has a ceiling. The ceiling is the point at which the procedural options run out, and the underlying judgment has to be addressed with something other than filings and appeals and motions. Trump's team has been extraordinarily skilled at keeping the ceiling from being reached. For years, across multiple cases, across hundreds of millions of dollars in legal fees, they have found ways to keep the options alive, keep the game in motion, keep the resolution perpetually approaching without ever quite arriving. This ruling moved the ceiling closer. Not through the ceiling, closer. And when you're operating in a space this tight, this close to the ceiling of your procedural options, every decision becomes higher stakes. Every filing either opens a door or closes one. Every public statement either helps the legal case or complicates it. And Trump's public statements, measured by their effect on his legal situation, have been making things more complicated for as long as anyone can remember. His lawyers know this. They've told him. They've told him in rooms with no cameras, in conversations that will never be reported, in the plainest language that professionals who charge by the hour can deploy. And he continues to say what he says, post what he posts, attack who he attacks, because the calculation he's making isn't purely legal. It's political. It's about the base, the donations, the narrative, the identity he's built that requires the fight to be visible and loud and total. The problem is that those two calculations, the legal one and the political one, are increasingly in conflict with each other. And when they conflict, the legal consequences are real, regardless of the political benefits. What happens now? That's the question everyone is asking. The question that legal analysts are modeling, that political strategists are wargaming, that financial advisors with exposure to Trump properties are lying awake, thinking about. The appellate process continues. There are arguments still to be made and courts still to hear them. Trump's team will make those arguments with everything they have, because that's what they're paid to do, and because some of those arguments have genuine merit that a different panel of judges on a different day might find more persuasive. But the trajectory is what matters. the direction things are moving, the velocity of the change. And all three of those indicators are pointing the same way right now, toward resolution, toward finality, toward the moment when the legal machinery stops generating new procedural opportunities and starts generating consequences. Trump's reaction to the Swift ruling was the reaction of a man who has been told, in the clearest legal language available, that the machinery is speeding up, that the space between his current position and the consequences is shrinking, that the tools that have worked before are working less reliably now, and that the next major decision, whatever form it takes, is going to force choices that no amount of political performance can substitute for. He went loud, because going loud is what he does. He attacked, because attacking is the move that served him longest. He claimed persecution because persecution is the frame that holds everything together for the people who believe in him. But underneath all of that, in the parts of this story that don't make it into Truth Social posts or rally speeches, something is shifting, something fundamental, the kind of shift that takes months to become visible, but that anyone paying close attention can start to see forming at the edges of things. Here's what's keeping legal observers genuinely up at night. Not the case itself, as significant as it is. What's keeping them up is what happens to the institutional framework when this concludes, however it concludes. If Trump wins on appeal, if the ruling gets substantially overturned, there will be a version of events in which aggressive civil fraud enforcement gets labeled judicial overreach, and future prosecutors think twice before bringing similar cases. That changes the deterrent landscape for financial fraud in ways that echo for decades. If Trump loses on appeal, if the enforcement mechanisms activate and the consequences land in the way that Letitia James has been building toward for years, there will be a version of events in which every politically ambitious prosecutor in America looks at this playbook and considers using it. And the people who will be targeted by those prosecutors won't all be guilty. Some will be, some won't. But the tool will exist, proven and ready. Both outcomes have implications that go far beyond this case, far beyond this defendant, far beyond this political moment. That's what makes this different from a normal high-profile fraud case. The outcome rewrites the rules regardless of which direction it goes, and everyone who understands what's actually at stake here is watching with a kind of dread that has nothing to do with partisan allegiance. This is the dread of people who understand institutions, who understand how precedents work, who understand that the legal framework that governs powerful people is extraordinarily difficult to rebuild once it gets destabilized. Trump's reaction to the Swift ruling was personal, raw, political, everything that his reactions always are. But the ruling itself and what comes next because of it is something much larger than personal, much larger than political. It is a moment in which the American legal system is defining in real time what it is capable of doing to the most powerful people in the country. And that definition, whatever form it finally takes, will outlast this case, this defendant, and this particular political era by a very long time. The clock is still running. The interest is still accumulating. The courts are still working through the remaining arguments. And Trump is still fighting, still loud, still certain in the way that only he can be certain, that all of this will be reversed, vindicated, exposed as the political targeting that he insists it has always been. Maybe he's right. Appellate courts have surprised everyone before. The law is genuinely complex in some of the areas his lawyers are contesting. There are legitimate legal scholars who believe the penalties are disproportionate, that the standard being applied is novel in ways that should give the appeals court pause, that the outcome here matters for reasons that have nothing to do with whether you like or dislike Donald Trump. Those arguments are real. They deserve to be taken seriously, even by people who are otherwise convinced that the underlying fraud findings are correct. But the Swift ruling suggests the court took those arguments seriously and found them insufficient. When courts move this fast, it means the deliberation already happened and the answer was no. It means the legitimately complex questions were resolved, at least in the minds of the judges ruling on them, in one direction. And the direction they resolved in is the one that moves everything closer to the moment of reckoning that Trump's legal strategy has been designed to postpone indefinitely. Indefinitely just got a deadline. Whatever happens next, whatever form the next ruling takes, whatever decision emerges from the arguments still pending, it will arrive into a situation that this Swift court decision fundamentally changed. The ground has shifted. The options are narrower. The timeline is shorter. And the reaction from the man at the center of all of it tells you everything you need to know about whether the people around him believe the remaining arguments will be enough. Watch the next 30 days. Watch who stays loud and who goes quiet. Watch which allies show up at the next rally and which ones suddenly have scheduling conflicts. Watch the financial disclosures and the property records and the bond filings that will tell the real story underneath the noise. Because something is coming. Something is always coming in cases like this. But this time, the something feels different, more concrete, more inevitable, more final than anything that has come before. And when it lands, trust me, no one will be pretending they didn't see it building.